Licensing fees are established by administrative regulations in 201 KAR 18040. Initial fees will be retained as an application fee if no license is granted. A license to practice professional engineering or land surveying will be issued if a candidate meets the requirements as set forth in KRS 322. The license will contain the signature and seal of the board, full name of the licensee, and the professional designation. A valid license evidences rights, privileges, and responsibilities for professional practice. If a license is labeled inactive or retired, this removes the right to practice. In order to be eligible for licensure by endorsement, an individual must currently hold a license in a state, territory, or possession of the United States, in the District of Columbia, or any foreign country. In addition, the individual must submit proof that the requirements and qualifications for the license that they currently have do not conflict with Kentucky requirements and are equal to or exceed Kentucky requirements effective on the date that their original license was issued. An individual may have to take state-specific portions of the land surveying examination. Again, it should be noted that the state-specific portion of the land surveying exam has been set aside and is not currently required. License renewal. For individual licensees, renewal is required every 2 years by June 30th, depending upon the first letter of your last name. You will renew in either an odd or even year. A business entity must renew every year by December 31st. Both the individual and the business entity must notify the board of any address change. Although the board is to notify licensees and permit holders of renewal, it is ultimately your responsibility to make sure that you renew in a timely manner. Failure to renew in a timely manner will result in a 10% penalty per month for failure to renew. After 1 year, re-examination can be required. Note that the penalty for failure to renew only applies to the action of renewing your license. Any practice of engineering or land surveying that takes place during a late renewal would be practiced without a current license. It is also important to note that during the renewal process, the licensee must indicate compliance with continuing professional development requirements. Making a false statement about this matter is unethical and can result in disciplinary actions. In addition, late renewal of your license activates an automatic audit of your continuing professional development hours. So renewing on time with your continuing professional development hours completed is the wisest course of action. Active duty personnel in the armed services can renew their license without a fee. In addition, continuing education requirements are waived for periods of active duty. A license or permit may be replaced if lost, destroyed, or mutilated, and may be reissued to replace revoked licenses or permits. Grounds for the denial of a license or disciplinary action are as follows: deception to obtain the license, gross negligence, incompetence, or misconduct in professional practice, violation of KRS 322, KAR, or the Code of Professional Conduct, employing, procuring, or inducing the unlicensed practice of engineering or land surveying, aiding or abetting the unlicensed practice of engineering or land surveying, or having been granted a license based on a mistake of material fact, are all grounds for disciplinary action or denial of licensure. While those practicing ethically would already be aware to not do many of the items listed, it is important to understand that each of these potential grounds of discipline are specifically codified because someone has already taken these actions. As we see from this first page of potential issues, a major key is to practice within the laws we have already been discussing. On the second page of the grounds for potential denial of licensure or disciplinary action, we see a conviction by a court of a felony. We see that the potential for discipline occurs when one has become a chronic alcoholic or drug addict, such that the continued practice of engineering or land surveying may become a danger to clients or the public safety. We see that if one has developed a physical or mental disability such that practice of engineering or land surveying could become a danger to clients or the public safety. Violation of a suspension or the terms of an order of probation issued by the board, or being subject to disciplinary action as a licensee in another state, can all be grounds for denial of licensure or disciplinary action within the Commonwealth of Kentucky. So we see two main themes. If you begin to reach a state of mind that means that the public safety may be affected by your actions, you have the potential to lose your license. Also, it is important to note that your actions outside of specifically Kentucky can impact your continued privilege to practice engineering or land surveying within the Commonwealth. A brief reflection on how becoming a chronic alcoholic or drug addict can impact the public welfare and ruin a surveying career. In Western Kentucky, we had a surveyor who performed very good work prior to becoming addicted to substances. Following behind his work, he would provide wonderful detail, ties to external positions to make the relocation of his boundaries much more easily accomplished, and in general did a very fine job of surveying when not affected by any substances. The board had to discipline this individual due to business practices which began to impact the public health, safety, and welfare, mainly the welfare of the public. Individuals were being asked to pay a portion of or all of a survey cost up front, and then the work was not being conducted. This led to many complaints, and the individual was disciplined and given an opportunity to make some changes, and was not immediately removed from licensure status, but the Board of Licensure tried to work with the individual to get them help in order to make changes in their life to continue to practice. So these rules and regulations are in place because they have to be in order to protect the public. This third page of grounds for denial of licensure or disciplinary action reiterate many of the aspects of practicing our professions which we've addressed in preceding sections, so we'll briefly just read through these. Conduct likely to deceive or defraud the public, the use of someone else's license, seal, or stamp, impersonating another licensee, using expired, suspended, or revoked licenses, certifying work not under direct supervision, and applying another licensee's seal, stamp, signature, or title block to your work. Each of these seem to be common sense that you should not do these, but again, I just want to clearly state each one of these items had to be placed within these statutes because someone has thought of and actually followed through on performing each of these actions. If investigated and any of the grounds for disciplinary action are found to be factual, the Board of Licensure has several options for addressing problems. For the simplest matters, a simple admonishment may be made. As matters become more serious, revocation of a license may ultimately become the resolution, with many steps in between. If evidence gathered during an investigation supports the complaint, an administrative hearing is supposed to take place as outlined in KRS Chapter 13B. Should a licensee disagree with the final order of any such hearing, an action through the Franklin Circuit Court may be pursued by the licensee. Potential consequences of being found to have violated the KRS or KAR statutes is that the board could refuse to issue a license, refuse to renew a license, suspend a license, revoke a license, provide a reprimand or admonishment, place someone on probation, or apply a fine not to exceed $1,000, or a combination of these possible consequences. Over the next several slides, we'll look at the composition and duties of the State Board of Licensure for professional engineers and land surveyors. This is an item that many licensees are not familiar with, and they see the Board of Licensure as some entity outside of themselves without much direct tie, aside from as a disciplinary figure. The board is composed of 11 members total. 9 of the members are appointed by the governor from a list of candidates submitted by the Kentucky Society of Professional Engineers and the Kentucky Association of Professional Surveyors, with input from other professional societies. And this list of names is to be provided at least 60 days prior to appointment. 2 members of the board are ex officio members with automatic appointment, being the deans of the University of Kentucky and University of Louisville engineering schools. Of the 9 remaining members, 1 must be a citizen at large with no association to the practice of engineering or land surveying. The remaining 8 members must be licensees with at least 12 years of experience, 5 of which must be in responsible charge. The licensed members of the board must have had their Kentucky license for at least 4 years prior to appointment and must remain actively licensed during their term on the board. So going back to the question of why be a member of your state societies, becoming a member of the Kentucky Society of Professional Engineers or Kentucky Association of Professional Surveyors will provide you with the opportunity to have a voice in who is placed on the State Board of Licensure. Your colleagues and professional peers who are appointed to these positions on the State Board of Licensure will serve a 4-year term beginning January 1st. They may serve 2 consecutive 4-year terms and then may serve again after a 4-year hiatus from service on the Board of Licensure. Members are compensated for their time on official duties of the board, such as the minimum 4 meetings per year, and this is addressed through administrative regulations. 6 members in attendance constitute a quorum for the Board of Licensure. While not an exhaustive list of the functions required of the board, here are some highlights of what they must do. They are tasked by law to promulgate the administrative regulations that we have reviewed in terms of the Code of Professional Conduct and which we will review as we look at the standards of practice in the next section of the seminar. They are tasked with appointing investigatory personnel and need to bring action in the Franklin Circuit Court against those practicing without a license or business permit. The board is tasked with adopting continuing education requirements. The board also gathers committees of licensees as needed in order to review issues before the board and make recommendations. This is often accomplished through seeking feedback from the professional societies within the state. Another opportunity for a shameless plug about becoming a member of your state professional society, either KSPE or CAPS, in order to have input in the direction of the profession. If you have ever used the board's website to look up a licensee using the online searchable roster, that is a required function of the board per KRS 322.330, Duties of the Secretary Treasurer. I will refer to this section as the enforcement powers of the board. As we saw, one of the duties of the Board of Licensure is the appointment of investigatory personnel. The board has also provided authority to subpoena witnesses and request documents needed in the investigation or administrative hearing of a case involving the revocation of a license or unlicensed practice. If one refuses to obey the subpoena or document request, the board can seek out support and request a subpoena be made by, quote, an authority having jurisdiction, end quote. From that point on, an individual not cooperating is probably violating a judicial subpoena. Once licensed, it is time to get your stamp. This is to be used when certifying reports, specs, drawings, and plans, and should only be applied if the licensee was in control of the work product. The design of the stamp is available on the board's website. This section of KRS specifically notes that affixing your stamp if your license is expired or to aid others in evading the laws is an unlawful practice. Again, make sure that you renew your license on time because if you don't, you are violating the law by stamping any work products during the time frame in which your license has lapsed. The electronic sealing and transmittal of documents, taken from a Board of Licensure frequently asked questions before the fairly recent revisions to their website. I will say, quote, "When documents are to be presented to a client or to a public or governmental entity, at least one copy must have the licensee's original stamp or seal, original signature, and date. Any other copy may contain a facsimile of the licensee's stamp, signature, and date applied manually or by computer." End quote. Begin another quote. "Yes, if the electronic signature is a unique identification of the licensee, is verifiable, is under the licensee's direct and exclusive control, is linked to the electronic document in such a way that any changes to the document are easily displayed, any attempt to change the document invalidates the electronic signature, and the document is transmitted in a read-only format." These answers are based on the information contained in 201 KAR 18-104. There are software programs which will accomplish this level of control over electronic signatures. If you are transmitting electronically, it might be worthwhile to look into these software programs in order to comply with this section of KRS. The recording of plats or surveys. No county clerk of any county or any other public authority shall accept for filing, file, or record any map, plat, survey, or other document related to the practice of land surveying unless it evidences certification by a professional land surveyor by whom or under whose personal supervision and direction the map, plat, survey, or other document was prepared. I'm sure we have all seen sketches or descriptions which were not prepared by a licensed surveyor but are of record in our clerk's offices. Note that this section of KRS 322 clearly states that unless certification of a licensed professional land surveyor is on the document, the county clerk is not supposed to record documents related to the practice of land surveying. We are very fortunate in the Commonwealth of Kentucky to have what is known as a right of entry law. Not all states provide this as a possibility for land surveyors, thus their access can be restricted. KRS 322.470 provides this right of entry as needed to locate property corners, boundary lines, rights of way, and easements. This right of entry includes personnel working for the professional land surveyor and allows for taking the customary equipment and vehicles with them. Such entry is not trespass, and the professional land surveyor will not be liable to arrest or civil action for such entry. Here is a question to ponder. In the course of an engineering design, it is often necessary to measure ground points in order to develop contours outside the bounds of the site. Would KRS 322, section 470, provide any right of entry in that case? I posed that question in the in-person seminars when presented, and it provides for some very interesting discussion. So as you complete this course, keep that one in the back of your mind and think about it. In the preceding slide, we spoke about the benefits of our right of entry law. With every right that we get, we seem to develop some sort of responsibility or obligation. The right of entry is no different, as there are corresponding responsibilities and obligations placed on the land surveyor. We are still responsible for treating others' property with respect. Cutting limbs and clearing line may be normal to us as land surveyors, but a landowner may not be happy to come home and find a traverse line cut through their hedges. Also, the property owner is not liable for injury or damage the surveyor or personnel may incur. So crews driving a four-wheeler around for fun are still a liability for the surveyor, not the landowner. Finally, while we enjoy this benefit, which is not available in all states, we are required to make a reasonable effort to notify the landowner that we will need to be on their property. Reasonable is not explicitly defined, so what occurs in practice may vary across the state. With more people moving to cell phones only, it is increasingly becoming more difficult to call ahead of time. A letter, a certified letter, a door hanger, a knock on the door. Each may be reasonable depending upon the circumstances, but you need to make sure that whatever you perform is a reasonable action that will hold up. One other discussion point that comes up in the in-person course is that this right of entry is essentially a law on paper or electronically controlled now, as you can find it on the internet. If you print this out on a card for your personnel to carry with them, it does not stop any negative actions from a landowner, and people are very serious about their property. So make sure that your crews understand that this right of entry is a law. However, it does not stop a landowner from shooting at them. So make sure your crews can understand when they need to leave a property. In the next two slides, we'll look at the idea of buildings or additions which require either an architect or professional engineer in the design process. The first slide presents instances which require an architect to provide services. However, it is noted that if alterations to the new construction are structural, mechanical, or electrical in nature, the services may be performed by a licensed professional engineer. These buildings include assembly buildings with 100+ person capacity, except church buildings less than 400 persons or less than 6,000 square feet. Businesses with a 100+ person capacity, institutional use regardless of capacity, mercantile with 100+ person capacity, residential with 12+ dwellings or 50+ person capacity, education buildings regardless of capacity, and mixed use meeting any of the above specifications. This slide presents instances which require either an architect or professional engineer provide services. That would include factory and industrial with 100+ person capacity, high hazard use regardless of capacity, storage with a 100+ person capacity, utility and miscellaneous with 100 person plus capacity. However, we should all still be mindful of the code of professional conduct and practice within our areas of expertise. Here is some incentive to follow the laws found in KRS 322. There are penalties associated with choosing to not follow the laws governing your profession. Any person who violates any provision of this chapter shall be fined not less than $100, nor more than $1,000, or be imprisoned not more than 3 months, or both. This wraps up a review of KRS 322, combining this section with the section on ethics in general, as well as with the section of the program addressing KAR 18-142. We can see that there is some reasonably clear guidance as to the expectations of professionally ethical behavior for professional land surveyors and professional engineers in the Commonwealth of Kentucky. We'll provide one brief activity concerning ethical decision making prior to moving on to the next section, in which we will be reviewing the standards of practice for professional land surveyors, often referred to as the minimum standards. I spent 4 years as a full-time faculty member teaching the surveying coursework at Murray State University. During that time, I was required to gather information and integrate learning goals within the program of study to comply with our TAC ABET accreditation. One of the items that needed to be worked into course outcomes was engaging the students in professional ethics. I purchased and read an interesting text called Fundamentals of Ethics for Scientists and Engineers by Edmund G. Seebauer and Robert L. Barry. The text is meant as an introduction to applied ethics and would be an excellent book for a college engineering course on ethics. The authors recommend an interesting take on what most people perform as a gut-level decision-making process. When faced with an ethical dilemma, develop a decision tree which will provide potential outcomes. Here is an example which is based upon a true beginning incident related on a surveying message board. You are out performing a boundary survey for a client. As you are making your way around the property, you come upon a brackets illegal substance prevalent in your area. This could be marijuana, methamphetamine, or whatever is being processed in the areas you work. Location. There is no one around, so you continue your work and make your way carefully around the area to close your traverse. I'm sure that many of us have run into these situations in our areas of practice. So using this scenario, let's analyze the potential outcomes of various decisions we could make by use of a decision tree. This is not meant to be an exhaustive decision tree, as there are still potential outcomes that can flow from each subsequent layer. However, it gives us an idea of how to apply the decision tree process. So starting at the top, we have a problem encountered which requires a choice on our end. Having found the illegal substances during the course of our work, we will need to make a decision in some manner. Our original discussion is having found a drug crop or processing occurring during the course of a boundary survey. However, for those engineers who may not be a dual licensee, this same scenario can easily be adapted by the discussion of finding the illegal dumping of some substance on a property while you are working on a design project. So at the top we see that we have discovered illegal substances. That is the problem. And from that we have to make potential choices. Working from left to right, We will look at each of these choices and possible outcomes of those choices. If we choose to do nothing, two options that come to mind easily are that the drugs being processed will be sold, or that law enforcement may just happen to find the drugs anyway. If found by law enforcement anyway, that may be fine and solve the issue, or your client may be questioned, and your client may also question you as to why you did not make them aware of this problem that you found during the course of your survey. If the drugs are sold, they may result in harm to the user of the drugs. If we choose to report to the client that we have found drugs being raised or processed on their property, they may be fully aware of the problem and tell us to keep our mouths shut. This provides us a big change to the ethical dilemma. Or they may thank us for letting them know and refer the matter to law enforcement. If we choose to report directly to law enforcement, the client may face problems if they were involved, and will certainly have some level of distress if not involved, but the responsible parties might be apprehended. An interesting portion that comes up whenever I use this as an example in the in-person course is the potential of the client having issues that results in not being able to or willing to pay you for your services. That is one to think about as we move forward through this course, but this is an example of a decision tree and how you can work out possible choices, the consequences of those choices, and this may eventually lead you to seeing the correct decision for you. Most of us do a similar process, maybe subconsciously, or we have a gut reaction to a problem that tells us this is our right choice. Let's take an opportunity to apply the decision tree making process. I'll provide this scenario, and then I would like for you to create a decision tree that would begin with conversation with a member of the public and see what options you have from that conversation that may be applicable, and then the potential outcomes that come about from various methods of approaching the conversation. Here is the scenario. Over a number of years, you have had dealings with another licensee who has been working in the same area as you cover. As the years have passed, you have frequently been less than pleased with the results of the other surveyor's work. Too often, you have had to contact the surveyor to discuss differences of opinion on the location of a boundary line and provided that surveyor with information which changed that surveyor's determination of the line. Although you can't determine that there is actually something that needs to be reported to the Board of Licensure, you do know that the other surveyor has been disciplined by the board in the past. After work, you are in the local Walmart picking up orange juice and a loaf of bread when a member of the public recognizes you as a surveyor. Perhaps you are still in your reflective safety vest. Joe Public begins questioning you about the practice of the other surveyor as he has just surveyed a property next door to Joe Public. This member of the public is very vocal that he does not think the other surveyor knows what he is doing and that he has messed up on the location of the line. How do you form your conversation with Joe Public about the other surveyor, and are there concerns you have about this conversation ethically or professionally? Branch off from the main concept of conversation about another surveyor's practice with a member of the public, with the various options that you could have in your decision tree, and see what the outcomes might be. Take about 5 minutes to approach this project.